and Mr. Arjun Kamath appear on behalf of the respondent, the Crown. I'll be contending the first ground of appeal, which is that the case of the Crown and Automako is a notorious one which fails to create sufficient clarity for juries in cases of gross negligence manslaughter. My learned junior will be contending the second ground, which is that key cases were not properly explained to the jury, and thus producing a conviction which is unsafe. Before contending the grounds of appeal, would your lordship appreciate a brief reacquaintance with the facts of this case?
Yes, please, very briefly, counsel.
I'm much obliged. Miss Tollhouse agreed to look after Colette, her 4-year-old granddaughter, while Colette's mother was vacationing in Ibiza. One evening, Mrs. Tollhouse pit bull terrier attacked Colette after having snuck into the house through an improperly shut door. While Miss Tollhouse reacted immediately, Colette was regretfully pronounced dead at the scene by responding paramedics. In relation to the first ground of appeal, I have two submissions to make. My first is that as per the case of the Crown and Automako, the jury was not properly directed as to the importance of considering the foresight of death as mens rea to establish gross negligence manslaughter. My second is that in applying the objective test of mens rea, as in the case of the Crown in Rose 2017, the reasonable person at the time would not have foreseen a death, therefore exculpating the defendant's liability in the present case. If it may please your lordship, may I proceed to my first submission?
Please proceed.
I'm much obliged. My first submission is that the jury was not properly directed as to the importance of considering the foresight of death as mens rea to establish gross negligence manslaughter. Please may I refer your lordship to the case of the Crown and Automako on page 9 of the case bundle. This case was first reported in the All England Law Report in 1994 on page 171. I humbly request for your lordship's permission to dispense with all citations to the rest of the moot. Would your lordship grant this request?
Granted, counsel. Please proceed.
I am much obliged. Would your lordship appreciate a brief summary, of the facts of this case?
No need, counsel.
I'm much obliged. Please may I now refer your lordship to the highlighted section of page 10 in the bundle, where the courts clearly state the need to consider mens rea when establishing criminality, stating, in a criminal court, the amount and degree of negligence are the determining question. There must be mens rea. This is a clear and unequivocal statement. Furthermore, if I may humbly invite the court's attention to the highlighted section of page 11 on the bundle. It is noted that judges have used many terms to describe the acts of those whose negligence amounted to a crime. Such words include culpable, criminal, gross, and wicked. Would it be fair to use these strong terms, commonly used in cases of professional or medical negligence, to describe a grandmother who has dedicated so much of her time and care towards Colette purely out of love for her granddaughter? It would be unjust to use the phrases I mentioned to describe my client. Indeed, in the highlighted section near the bottom of page 11 of the bundle, the court notes that the conventional objective test of manslaughter requires the prosecution to satisfy the jury that the negligence or incompetence of the accused showed such disregard for life and safety for others as to amount to a crime against the state. This is a very high watermark, not satisfied by my client. If it may please your lordship, and barring any questions, may I proceed to my second submission?
One question, counsel. Why should this court consider that this is not within the scope of the epithets, as you have clearly, helpfully pointed out, within the Automako? Because from what this court has understood, there has been a history of behavior that would make a reasonable, as you said, loving grandparent even aware that a very, very high level of care needed to be put in place in order to make sure that the dog would not attack the child. Would you describe the grandmother's behavior in actually consuming cannabis, alcohol, and playing loud music, meeting that very, very high standard of care required, bearing in mind, again, the history that existed in the present situation?
I'm much obliged. In response to your question, my client in this case has taken all reasonable steps to prevent the dog from entering the house, including putting the dog outside and shutting the door. She's also taken on parental responsibilities that she otherwise would not have had should Colette's mother not have been vacationing in Ibiza. Therefore, my client has taken on additional responsibilities and taken measures to safeguard Colette's well-being. And therefore, it should be disregarded that my client has created this incident. Would your lordship, would that satisfy your lordship?
Yes, please proceed.
Yes. Please may I now refer your lordship to the case of the Crown and Rose on page 23 of the case bundle. Would your lordship appreciate a brief summary of the facts of the case?
No need, counsel. Please proceed.
I am much obliged. Please may I refer your lordship to page 24 of the case bundle in the highlighted section of paragraph C, where the courts directed the jury to consider whether it was reasonably foreseeable that the breach in duty of care gave rise to a serious and obvious risk of death. Furthermore, in the highlighted section of paragraphs F and H, the court states that the jury ought to consider whether the risk of death would have been obvious to a reasonably competent individual. In this case, the appellant has acted with the pure intention of protecting the well-being of her granddaughter, which she had voluntarily looked after while her mother was off holidaying in Ibiza. My client has demonstrated a strong regard for the safety of Colette, even putting her own life at risk by attempting to pull the dog off Colette. She will live with regret and has done all she could to avoid and mitigate risk. For the reasons I've given, the counsel for the appellant respectfully invites the court to allow this appeal. Barring any questions from your lordship, that concludes my submission.
Thank you, counsel. No further questions at this point.
I'm much obliged.
May it please your lordship, as has already been indicated, my name is Leo Hussein, and I appear for the appellant on the second ground of appeal. I have two submissions to make. Firstly, that following the Crown against Bateman, to establish criminal liability, the facts must be such that in the opinion of the jury, the negligence of the accused went beyond a mere matter of compensation between the subjects and showed such a disregard for the life and safety of others as to amount to a crime against the state and conduct deserving of punishment. And secondly, that by applying this principle, the defendant's actions do not amount to gross negligence and thus the conviction is unsafe. May I proceed with my first submission?
Please proceed, counsel.
I'm much obliged. As referenced in the submission, please may I refer your lordship to the case of the Crown against Bateman, reported in the All England Law Reports reprint, volume 42, 1925. Going forward, may I citations.
Yes, counsel, you can.
I'm much obliged. Here, a doctor was convicted of manslaughter arising out of his treatment of a woman in childbirth. And whilst the circumstances of the case are not wholly analogous to the one at hand, the legal principles do apply. Specifically, may I please refer your lordship to page 17 of the e-bundle in the highlighted section, where Lord Hewitt states that in order to establish criminal liability, the facts must be such that in the opinion of the jury, the negligence of the accused went beyond a mere matter of compensation and showed such a disregard for the life and safety of others as to amount to a crime against the state. In this dictum, Lord Hewitt lays down clearly the high bar that must be met for a conviction of gross negligence manslaughter to be sustained. By referring to a matter of compensation, Lord Hewitt makes clear that the failure of care or concern must be more like a civil liability. That standard is that of gross rather than mere ordinary negligence. The difference here refers to the degrees of negligence. It will be gross if the defendant's conduct not merely fails to meet the standard set by the reasonable person test, but falls so short of that standard by a considerable margin. In short, the defendant's actions must not merely be unreasonable, but very unreasonable. Counsel submits that this is the crucial point in this appeal. By failing to clearly explain to the jury the exceptionally high bar required to find a guilty verdict, the trial judge, His Honour Judge Cohen, made the conviction unsafe. Indeed, the trial judge did not heed this dictum of Lord Hewitt, that juries should be cautious when attributing criminality to a defendant who has neither intended nor foreseen that they would cause harm. Counsel submits that based on the facts of this case, the appellant categorically did not reach this high bar. May I now refer your lordship to the case of Andrews against the Director of Public Prosecutions. In this appeal, the appellant's conviction for manslaughter was upheld after he drove a van above the speed limit and overtook another car, striking and killing a pedestrian. In his judgment, which can be found on page 6 of the e-bundle in the highlighted section, Lord Atkins endorses Lord Hewitt's dictum, stating that simple lack of care, such as will constitute civil liability, is not enough. For purposes of the criminal law, a very high degree of negligence is required to be proved before the felony is established. In short, counsel submits that based on the relevant and binding case to disregard for life and safety of others to amount to a crime against the state. This is far slain to the jury by the trial judge, and indeed higher than what the appellant's actions in this case would amount to. That concludes counsel's presentation of documents concerning the first submission, and unless your lordship has any questions, I would like to move on to the second submission.
Very briefly, counsel, similarly to what I asked the leading appellant, bearing in mind the history of the behavior and also the unfortunate features of the pit bull terrier breed and their proclivity for aggression in some situation, would you not say that the grandmother did actually have should have had a very good foresight of what might happen if she was negligent?
I'm much obliged for the question, my lord. I would note that moving on to the second submission, I will address in more detail the facts of the case, but to respond briefly to your question, I think that the actions of the appellant shows that she did indeed foresee the potential threat shown her granddaughter. She took the precaution of putting the dog in the garden. Briefly moving to second submission. When examining the facts of the case, no one would argue that the appellant acted in a way that was honourable or reasonable or commendable. But as established, the law does not require her to have done so. She simply didn't need to act in a grossly unreasonable way. And by risking her own life to try and save the child, by responding immediately as soon as she heard her granddaughter was in distress, that shows that she did not act in the exceptionally unreasonable way that she was required to. Counsel for the respondent may argue that drinking and smoking cannabis whilst looking after the child was unreasonable. This may well be the case, but given that that was the appellant's custom in the evening, it was not very unreasonable, and that is the crucial test. That concludes counsel's submission of documents for the second submission. I think that counsel submits that the exceptionally high bar required to render a guilty verdict in the not been met. As such, the conviction is unsafe, and counsel invites the court to quash the appeal. I'm much obliged.
Respondents, when you're ready.
May it please your lordship, as has already been indicated, my name is Amelie Knagi, and I appear on behalf of the Crown as the respondent on the first round of appeal. I have two submissions to make. My first is that as per the Crown and Adamaco, the elements of gross negligence manslaughter have been clearly outlined, and the reliance in this case does not jeopardise the safe and satisfactory conviction made by the jury and upheld in the Court of Appeal. My second is that Adamaco has laid down clear, simple guidelines for gross negligence manslaughter, and any further changes in the law regarding this matter should require legislation from Parliament. If it may please your lordship, may I please proceed to my first submission?
Please proceed, counsel.
Much obliged. As per the case of the Crown and Adamaco, which can be found on page 6 of the court bundle, The elements of gross negligence manslaughter have been clearly outlined. This case was first reported in the first edition of the Appeal Cases in 1995 on page 171. I humbly request that I dispense of all citations for the remainder of this moot.
Please dispense, counsel.
I'm much obliged. Would your lordship appreciate a brief summary of the facts of this case?
No need, counsel. Please proceed.
Much obliged. There are 5 key elements for gross negligence manslaughter, and they are as follows. There should be a duty of care, a breach of that duty, reasonable foresight, causation in relation to the death, and the conduct displayed by the defendant must be considered grossly negligent. The duty of care is largely taken from the civil law interpretation, wherein the duty owed is wherever the defendant's conduct carries a foreseeable risk to those around them. Relative to the present case, there is quite a clear duty between Nestle Tollhouse and Colette, her granddaughter, who she has willingly taken responsibility for. In regard to the breach of that duty of care, we must examine the conduct of the defendant. In instances where the defendant's omission causes the death, which applies to the present case, the standards of omission liability apply. In this instance, it can be said that Nestle Tollhouse has still breached her duty of care, as she has assumed responsibility for her granddaughter, and she has a duty to protect her from the dangerous situation she has created by failing to keep the dog away from her granddaughter. The case of the Crown and Evans can be used to illustrate this on page 14 of the court bundle. Though I'll be relying on the obiter of this case, would your lordship still appreciate a summary of the facts of this case?
No need, counsel. Please proceed.
Much obliged. Where Lord Diplock states that he could not see no rational ground for excluding conduct which consists of failing to take measures that lie within one's power to counteract a danger that oneself has created. With relation to the element requiring there to be reasonable foresight, this counsel argues that there must most certainly reasonable foresight that the conduct of the defendant would result in serious injury or death. My learned junior will further elaborate on this matter in his submissions, but I would also like to take a moment to rebut something my learned friend has made in his submissions. In his submissions, my learned friend has mentioned the case of Rose. This counsel would like to distinguish the present case from the case of Rose. In Rose, the defendant there had not seen the scans, which would have given her an insight into the foreseeable risk that the patient was under. In the present case, Nestle Tollhouse had a clear pattern of aggressive behaviour displayed by her dog. She acknowledged this behaviour by consistently putting the dog outside of the house every time her granddaughter visited. It is undeniable that any reasonable person would have assumed she was aware of the foreseeable risk the dog carried. The element of a causation between the defendant's conduct and the death of the victim is clear in this case. In instances involving an omission-based negligence manslaughter, a reasonable person would have to consider what the defendant would have done in that position and whether that would have stopped the victim from dying in the manner that they did. In the present case, a reasonable person would have locked the door properly, given the fact there was an aggressive pit bull terrier in the vicinity. This would have prevented Colette from being mauled to death in the living room floor. This fulfills the causation element of this offence. With the final element of gross negligence manslaughter is one of the most heavily contested elements, the requirement for the conduct to be grossly negligent. This element was discussed at length in the case of Adamaco, where, to paraphrase Lord Mackay on page 8 of the court bundle, the jury might properly find gross negligence on proof of actual foresight of the risk, coupled with the intention to avoid it, but involving such a high degree of negligence in the attempted avoidance as the jury would consider the conviction justified. In the present case, this counsel argues that the appellant had actual foresight of the risk of injury to health and the intention to avoid it, but was involved in such a high degree of negligence in the attempt to avoid it, it would be considered justified for the conviction to be upheld. This concept is supported by the case of the Crown and Mistress, where Lord Justice Judge says on page 20 of the court bundle that the circumstances were so reprehensible as to amount to gross negligence. Though I'm relying on the obiter, would you still appreciate a brief summary of the facts of this case?
No need, counsel. Just a very quick question for you here. Had the circumstances been different and that Colette, more fortunately, did not end up, as you said, dead on the floor, but was merely attacked by the dog without any consequences, Would you still consider this to be grossly negligent behavior on behalf of the grandmother, or are we confusing the severeness of the outcome with the grossness of the negligence involved?
Thank you for your question, my lord. In relation to this question, I would argue that the conduct of the defendant was most certainly grossly negligent. The outcome, while severely tragic, does not detract from her behavior in consuming copious amounts of cannabis and intoxicating herself on alcohol while with the responsibility of supervising a 4-year-old child. This conduct in itself shows grand degrees of negligence and a complete disregard for her life in essence. And the outcome of this is proven by her death. If that satisfies your question, may I please proceed with my submissions?
Please do proceed, counsel.
In looking at the circumstances, the jury must consider the appellant's motives and so on. And upon the analysis of these circumstances, it would be reasonable for a jury to convict the appellant for gross negligence manslaughter. The conditions are as follows. The appellant had intoxicated herself on cannabis and alcohol and left a 4-year-old unsupervised and had an aggressive pit bull terrier in the local vicinity who still had access to the house. Consequently, the child was killed. This is therefore reasonable for a jury who analysed the criminal liability of the appellant using these clearly explained elements to convict the appellant of gross negligence manslaughter. If there are no further questions, may I please have some extra time to complete my second submission?
Please do, counsel.
I'm much obliged. Adamako has laid down clear guidelines for gross negligence manslaughter, and any further changes in the law in this area should require legislation from Parliament. Adamako is a key case when assessing gross negligence manslaughter. Some may argue that the definition of gross is circular and confusing. As for the conduct to be gross, it must be criminal, and for it to be criminal, it must be gross. And while we acknowledge this, however, this counsel supports the argument made by Lord Mackay on page 9 of the court bundle in the case of Adamako, where he says that to a certain extent, it involves an element of circularity, but this branch of the law, I believe, is not fatal to its being correct as a test to how far conduct must depart from the accepted standards to be characterized as criminal. He further goes on to say that any attempt to specify that degree more closely would result in false precision. This counsel is in complete agreement with these statements. Although imperfect, the law as interpreted by Adamako is pivotal to the law of involuntary manslaughter. I'd also like to briefly point out that Adamako is a key case when dealing with manslaughter which occurs through omissions of an appellant's actions. Removal of such a case would create a void in the law and narrow the already fairly narrow scope of the law, which is already regulated with the elements of this offence. It is with these arguments that the lead counsel of the respondents concludes his submissions. Barring any further questions, the counsel of the respondents respectfully urges the court to deny this appeal.
Thank you, counsel. No further questions.
Before I start, can I just check if everyone can hear me?
Yes.
May it please your lordship, as had already been indicated, my name is Arjun Kamath and I appear for the respondent, the Crown, on the second round of appeal. I have two submissions to make, which are as follows. Firstly, the trial judge's direction to the jury as the appellant's own foresight adhered to the precedent established in Attorney General's reference number 2 of 1999, thus rendering the conviction safe. Secondly, upon consideration of Lord Mackay's judgment in Adamako, it's evident that the case facts corroborate the truly outrageous and gross nature of the defendant's breach for it to be criminal. Therefore, the conviction is not only safe, but equally just. If it pleases your lordship, may I proceed with my first submission?
Please do proceed, counsel.
I'm much obliged. To begin this first submission, counsel would like to direct your lordship to Attorney General's reference number 2 of 1999, which can be found on page 23 of our e-bundle. My lord, I will be relying on the principle established in this case rather than the facts. Would your lordship still appreciate a brief summary of the facts of this case, however?
No need, counsel. Thank you.
Very well. Counsel specifically refers your lordship to the highlighted section of Lord Justice Rose's response to the Attorney General's question, and this can be found on page 25 of the bundle. And the Attorney General asks the Court of Appeal if the defendant can be convicted of gross negligence manslaughter despite a lack of evidence as to their state of mind. Lord Justice Rose's response to this was as follows: though there may have been instances where a defendant's state of mind is relevant for jury considerations when considering the grossness and criminality of their conduct, evidence nonetheless is not a prerequisite for a conviction. And he also goes on in the next sentence to affirm the objectivity of the Adamaco test. In light of this, counsel would like to turn your attention to the facts of the case, which can be found on page 3 of the bundle, as it contains an incredibly important part of the direction which concerns my submission and this appeal as a whole. In directing the jury on the matter of the defendant's subjective foresight of the risk of death or serious bodily harm in relation to her breach of duty, the trial judge informs them it is not an important factor when assessing whether the defendant breached their duty of care. Would your lordship not agree that this is a perfectly clear explanation of the ratio laid down in Attorney General's case, and one which was simply adhering to the precedent of a higher court? As the court is aware, at the time of the duty breach, the appellant was in an intoxicated state, which was customary for her during the evenings. Counsel also stresses that putting the question of whether the defendant subjectively foresaw the risk of death or serious bodily harm would not have only subtracted from the clarity of the direction trial judges ought to give in an area of the law which has widely been acknowledged as being rather complex, but would also have undermined the objective nature of the Adamaco test, which is essential. Thus, as the procedural elements of this case were legitimate and valid, the counsel submits that the conviction is safe. If your lordship has no further questions, may I proceed with my second submission?
Sorry, counsel, just a quick question, because we heard a lot about this. What does the customary nature of the behavior of the grandmother, does it change any aspect, whether it comes to gross negligence, foreseeability, or any other aspect?
Thank you for your question, my lord. So obviously, as we know, it was routine for her to consume weed and alcohol, and obviously listen to the radio in the evening. Counsel would argue in response to your question that it is nonetheless a really important part of the case, and what is being appealed in a much broader sense. And this is something I will cover in my second submission to a much greater degree, if that's all right.
Thank you, counsel. Please proceed.
I'm much obliged. As the court is aware at this point, a point of contention may be that in his direction, His Honour Judge Cohen instructed the jury that in order for Miss Tollhouse to be convicted under her charge, her negligence had to amount to an absolute howler. Understandably, this is a rather confusing phrase to grapple with and may have just been said for a dramatic purpose. Nonetheless, the counsel submits that this was a legitimate characterization of the Adamaco rules. To elaborate, counsel would like to refer your lordship to the leading authority on this area of the law, the Crown against Adamaco, which can be found on page 6 of the bundle. Before I continue, would your lordship appreciate a brief summary of the facts of this case?
No, thank you, counsel. Please proceed.
Very well. Specifically, counsel would like to direct your lordship to the first highlighted section of Lord Mackay's judgment concerning the final limb of the Adamaco test, which can be found on page 9 of the bundle. He essentially held that when considering if a breach of duty meets the threshold of being gross to warrant a criminal conviction, the jury will need to consider the seriousness of the breach committed in light of the defendant's circumstances. Furthermore, the jury would need to consider the extent to which the defendant's conduct departed from the incumbent standard of care, which was imposed upon them. As mentioned before, counsel submits that the trial judge's description of the negligence needing to amount to an absolute howler was justified. As we know from the facts, the circumstances were such that the appellant was not only in a position of authority that night over her pit bull terrier, but in a position of care and responsibility over her 4-year-old granddaughter, for whom she had to look after during that week. My lord, I appreciate I am out of time. However, I humbly request to have some extra time to carry on and finish my submission.
Please do, counsel.
I'm much obliged. Counsel submits that in light of the factual context of this appeal, His Honour Judge Cohen may have implied that the appellant's breach had to be so outrageous and demonstrate an indifference towards the fatal risks associated with her circumstantial responsibilities to warrant a conviction. On that note, counsel would like to now focus on the issue of the conviction itself and submits that in line with the Adamaco rules that the conviction was safe. As my learned senior has established in her submissions, not only was there a duty of care which was breached, but there was also a causal link between Colette's death and the duty breach. Firstly, as a result of the appellant's failure to properly close the back door, it's evident that there was a risk of serious injury at the very minimum and a risk of death at the most extreme. By allowing her pit bull terrier, whose breed, by the way, is known for being incredibly strong, and they're known for being very vicious dogs, so much so that they're actually banned under government legislation passed in 1991, to enter the house and be in the same vicinity as her granddaughter, who'd previously been on the receiving end on many instances of the dog's aggressive behavior, to the point where she's described as being frightened. It's obvious to the reasonable man that Colette's safety at that point was immediately compromised. This brings counsel on to their next point about why the breach was sufficiently gross and thus criminal in nature. As alluded to before, that night the circumstances were such that the appellant was not in a position of authority, but one of care and responsibility. Previous interactions between Colette and the dog had been so concerning that she agreed with her daughter to keep the dog in the garden whenever Colette was around. Thus, not only did the appellant's breach reflect her ignorance of something so simple, i.e. just shutting the back door of the house, yet so crucial in ensuring the victim's security, but also her indifference and lack of attention for someone who was very familiar with the abilities and the danger her dog posed. Additionally, counsel stresses that evening was not a normal evening for her, as she had to care for her granddaughter, and the fact that she indulged in controlled substances, despite having a 4-year-old whose life was in her hands, underlines this indifference for her granddaughter's life and need to be prudent and alert. And that's something which was attached to her incumbent duty of care. In lieu of these factors, counsel stresses that the jury's decision to convict the appellant was not only safe but equally just, as it's fundamental that the state holds individuals like the appellant who demonstrate such callous disregard for human life accountable. Surely would your lordship not agree that, contrary to what the appellants may submit, or have submitted rather, that by overturning this conviction, a much greater injustice will be done to Colette, a child who is not only deprived of the fruits and joys of life, but whose death was so easily preventable? Unless your lordship has any further questions, that concludes my submissions on this ground of appeal. Counsel for the respondents respectfully invite the court to deny this appeal. I'm much obliged.
Thank you, counsel. No further questions.
Appellants, if you want to take your right of reply, you have 3 minutes.
I'm much obliged. My learned friends has centered on the fact that my client may have had the foresight or should have had the foresight of risk. However, let's focus on the facts of this case. It would be the grave injustice and a miscarriage of justice should my client's mens rea not be considered. My client has voluntarily taken on additional responsibilities of taking care of a young child that she otherwise not had the child's mother not been vacationing or have neglected to take care of her own daughter. My client will live with the regret of the death of the child forever, but we should focus on the fact that the predictability of this incident was far from solid. No one could have reasonably foresaw that by taking reasonable steps, such as placing the pit bull in the garden or shutting the door, no one could have reasonably foreseen that by taking these steps, a child could have died. No reasonable person could have made that connection between taking reasonable precautions and the death of a child, which is in itself regrettable. I would also like to highlight, as for the case of the Crown and Automaco, that it is important a person in my client's circumstances appreciated the risk, and that in this case, any reasonable individual who is of my client's age, who has a normal routine of using certain substances and alcohol, would act significantly differently at her own cost to mitigate a very, very remote risk of the pit bull attacking Colette, simply because sufficient mitigating measures have already been taken by my client. And additionally, and finally, my client has acted immediately and heroically the second she noticed there was a concern. She put her own life at risk. That shows the court the care that my client has for her granddaughter. And that should be taken into consideration.
Thank you, Harry. So the mooting round has just ended. We will give our judge, Dr. Velimir, a couple of minutes to make his judgment and give his feedback. But thank you guys for coming. We're not done yet. We'll just stay tuned till the end for the judgment. But well done to our expert mooters. They've done such a great job. So proud of you guys, honestly. So actually, we want to show you guys a couple of mooting opportunities that are ongoing this year. So if Dylan could turn on his mic. Yes.
Yep, just to reiterate what Belinda was saying, absolutely fantastic from our expert mooters. You should be really proud of yourself. That was definitely a thrill to watch from each and every one of you. I think you really held your own, and it was something that was very, very, very impressive. So, you know, well done, guys. Yeah, so, well, we hope you enjoyed that, viewers in the audience. Now it's just the section where we just talk about mooting more generally and why we think it's a good idea for you to join the mooting. So we think there's so many transferable skills which you can develop through your mooting participation. I think the strongest one is confidence and how that kind of interplays with your public speaking skills. So the ability to speak in front of how many people and confidently articulate your arguments and, you know, dismiss an opposing argument and suggest why your argument is stronger than another argument. It's all of these soft skills which are developed through mooting. So these skills are very, very, very valuable and are skills that you can take into various aspects of your life. The scrutinization element as well, when you're going through a case and you're being able to dissect the most important bits of information from the least important bits of information, where you're able to understand where an opposing argument may fall and where the opposing argument may succeed, and be able to poke holes. So these are another skills which are all developed through mooting, especially helping to build up on your research skills, which is very, very important as it provides as a complement to your academic knowledge. Belinda and I will base our mooting problems on the areas of law that will be covered within the law course, which is something that is very, very helpful, because when you get to like a specific section in your in a specific module, you'll have almost disadvantage over your other peers who haven't done mooting, because you're aware, okay, I've done this before, and even if I haven't done this specific topic, I'm aware of what I need to do in order to approach it. This is how I'm going to research it. I might use this, I might use that, but this is how I'm going to be able to mold a strong argument or mold my understanding around it. So that's just a couple of reasons why we think mooting is a very invaluable experience and something that we really, really urge you to get involved in.
Okay, so sign-ups actually opened for the first year competition today. We'll show you the link and send in the link through WhatsApp, through all our social media, but they opened today. It's going to be in the next slide, so you can just scan the QR code to sign up. It's okay if you don't have a partner. We'll obviously pair you guys with other people. We also have a really exciting speed moot at the end of term 1, so it's going to be like a 24-hour kind of moot. The first year competition, as of now, we will be holding it virtually because we know not everybody's on campus and some of you guys are still studying remotely. So we want freshers to have the opportunity to moot anyway, and it will be, you know, easier, help you ease into the process of mooting. So for term 2, we have the internal mooting competition, and that will be very significant because our final is in the Supreme Court. And also in term 2, we have commercial moot, and we also have inter-varsity moots with other universities, and we will also inform you guys of the external mooting opportunities. We will be posting these updates through WhatsApp, and also please join the Law Society Discord server because we also put the sign-ups, updates, and everything in there. So please join our Discord server and follow us on Instagram if you haven't yet. So the next slide, so this one is the first year competition. I will insert the link to sign up for it, but you can just scan this QR code with your phone. It's just easier that way, but we'll make sure to promote it in the next few days. So this is obviously only open to first years, but our speed moot this term, at the end of this term, near the end of this term, will be open to all years. Want to prioritize, I'm pretty sure a majority of you watching right now are first years, so this is a really, really exciting process, and I'm really pumped to see what you guys have in store. We also have a How to Moot workshop tomorrow on 12 p.m. the same time on Microsoft Teams. We will be sending the link on WhatsApp after this, and also on Discord, just to make sure. So please join our Discord server. We have a Mooting channel to put all our updates and things like that. So if you guys, we'll still be waiting for Wildman, but if you guys have any questions, you can just ask away right now. If you have any questions, you can turn on your mic and stuff, but Velimir, are you ready for the...
Thank you, Berlinda. Born ready, as they say, right? First of all, congratulations, everyone. I mean, this was a really, really high level of advocacy when it comes to mooting, the level of preparedness, the level of knowledge of the law, of the facts, and the readiness to stand ground for your client, all obviously at a very high level, and I really enjoyed listening to your presentations. These are general comments which now apply to all of you, and these are mostly praises. All of you, the level of politeness, the structuring of your argumentation, all of that, I really don't have any problems with that. You're obviously well versed in the subject matter. The relevant cases that you mentioned are actually relevant, obviously, and the relevant bits in them were explained clearly, and our attention was drawn to them quite clearly as well. So in that sense, I would say that substantive aspects are really well done, and I would like to congratulate you on that. Okay, so a lot of reasons to be proud of your performance today, and I'm sure that our audience had a wonderful opportunity to see how this looks like at a really, really good level, and how it should look like, right? Good. Now, I want to go. Obviously, in terms of judgment. Okay, like I told you in the beginning, this is not something like that. As a judge, after listening to everything and bearing in mind that, objectively speaking, the defendant here or the appellant in the presentation is not in a particularly good position, and I'll go into this also a bit later. As a judge, I would have gone for respondents or for the Crown. Okay, when it comes to law and everything, I would have gone to the Crown. And in that sense, but that doesn't mean that the appellants didn't make the best case they could. It's just simply that objectively, it would be hard to overturn this. Okay, so that's in terms of judgment. But this is really a secondary aspect of it all, right? Now the important bit is to go and see in terms of your presentations, in terms of your style, and in terms of some technical details, what we can, go even further, right? And also for all our first years to pick up early on some of the pointers. Okay. So how do we go about this? Of course, when I say something to individual speakers, is obviously it's relevant for everyone else in that sense. It's just that I picked up some things with someone else or not. Okay, let's go in the order of performance. Harry, obviously a very good performance. Really, in terms of presenting, the pace. It's a good pace. It's clear what you want to say. Politeness, courtesy, all that towards the court, all very well done. I asked you for the the details of the case, which you might have expected or you might not have expected, and that in that sense it was good that you had a very brief version ready, so that was very good. Overall, so like I said, it's a very good performance. Now, what we can focus on in terms of timing, okay, and this is a more general point. All of you ran overtime to some extent, okay. The point is, and that happens in mooting. That happens very, very often in mooting, and that's absolutely not something that you will be able to avoid at all times. The point is how you deal with this. So, Harry, I ask you for elaboration of facts. I put a question to you, and still you were very, very slightly over time, which is really good. Okay, so that's a good performance. Leo, again, I asked a question which derails you. You were more over time than Harry was, right? And that then raises the question whether you should do what the respondents did, which is to ask for more time. Okay, so Emily, Arjun, it's a good practice to ask for more time if you know that you're going to be over time quite considerably, right? You have in your mind how much you still need to say, so obviously you will have an idea, if it's something that literally you're going to wrap it up in 15 seconds. You just need to get 2 sentences in, pretty much as Harry had the opportunity. You can get away without needing to ask specifically, right? But if you know it's longer, it's a good practice to ask. Now, the caveat on that is that if you're asking for more time, to show that you are in control, you tell me how much more time you want, and then stick to it. If you tell me I want another minute, okay? If I want another minute, stick to that minute, okay? That shows you went over time for whatever reason, but you were still in control. You knew how much you had, and you stuck to that. That's great, right? So a couple of points. Asking if you know you need time, ask for it. But if you're asking for it, the best practice, tell me how long and stick to that. Yeah. So it shows that you're in control of your own submission. Harry, 1 point. I know that all of you know the case by inside and out, right? And that you know the arguments which will be raised also by the other side. Now, Harry, do try to avoid nodding when actually the opposite, the counsels for the opposite side are making their arguments. It's the same as in Parliament, right? So even if involuntarily, oh, this is a good argument. Yes, that's also the thing I would say if I was on the other side, which is fine to think in your own head. But if you are nodding, along that, it seems to the judge, oh, well, obviously he's agreeing that his case is being destroyed. The same thing as in Parliament if the opposition is not nodding when the government is speaking, right? On the contrary, please do not make any howling sounds, strong appearances of disagreement, throw objects at the opposing counsel. That might be a bit over the line, but it's just that while the opposing counsel is presenting, you are respectfully listening, right? But it doesn't need to be that respectful to actually start nodding along to their arguments. That. On the other hand, you were also nodding along for your junior, which is perfectly fine. Don't overdo it. You didn't, but as a general point, don't overdo it. You're cheerleading obviously for your co-counsel, but if you're doing it too much, it might become just a little bit, too much. Well, yeah. So that's on that. In substantive terms. Again, general point. It's a good. I'm not convinced by the whole line of argument saying, okay, she voluntarily accepted this additional responsibility. She volunteered to do this. Well, okay, she did. Okay, yeah, but she did. And then if she did, then there's the duty of care and not to be negligent. Saying that she did that, extra voluntarily, I don't think it adds much, right? The argument that, well, she risked her own life to save the child, again, well, what else is she going to do? I mean, if she was just sitting there looking at what's happening, then obviously this would be a non-starter at the beginning with. Now, and this also goes for both of you. It's good to, it's good if done well, tugging on these, on the heartstrings, I would say, of judges is fine, right? So you ask, well, a child has been murdered. It doesn't get much worse than that. And obviously, respondents, they did their best to show that the dramatic of the situation, young life lost at the very beginning, right? As that goes, there's also the need to, again, the judges are human beings, and you might want to be careful with how much you're pushing certain arguments. And it might be trivial. If you're pushing an argument, oh, the mother had the nerve to go to Ibiza and leave the child with her grandmother. If only she didn't do that, oh, well, we wouldn't be here, right? It might sound sensible, but I have small children. I have a dog as well, actually. And I might want to go to Ibiza, right? And so if I leave the child with their grandmother, am I a bad parent? Right? Like, is that such a bad thing to do? Right? So you bear in mind that, the judge is sitting there might be, is this a good argument, or is the counsel actually admonishing me involuntarily, right, unwittingly? But am I being admonished here for doing this? So sometimes, there's this element, a human element of thinking through, how is the argument going to sound to a judge who might actually have young children and dogs and grandmothers as well, right? So there is that element. And also in the reply, pushing it like really, no reasonable person would think that this is or that might be, there is a limit when you might be going too hard for your client in the circumstances. I think there would be plenty of reasonable people who would say, listen, if you have a pit bull terrier, if you please don't get stoned and completely out of your wits whilst taking care of the child. Okay, that I wouldn't say that there is no reasonable person who would think this. Okay, so I know you're pushing the hardest for the client, but there are limits to that, right? In this case, again, I'm not a criminal lawyer, but in this case, I would rather go, there's a fine line, but I would go for this into more towards the line of obviously this is horrendous. Obviously she's been negligent. Pushed it. There's this sort of penitence line almost there, right? But we are here for a legal standard, okay? It's tough, but we are here for the legal standard and focus just on this, right? Trying to fight too much that this is horrible, it's a harder line to follow, right? But overall, I mean, you did the best you could for your client, I would say. So that is good. Leo, I mentioned so some points about time as well. There were technical issues with your presentation, which is not your fault. So it was a bit harder at some points, including I think at this point, because the picture is frozen, or Leo is really good at keeping still. There we go. Yeah, unfortunately there were some technical issues. It didn't impact in the grand scheme of things. I don't think it impacted so much, but it made it harder a bit to follow. Again, with the timing, yeah, if you're asking for some extra time and following through with it, that's pretty much the best. Otherwise, presentation, pace, polite, I think that was all quite fine. And substantively, I think that's pretty much what you can say from your client's perspective. I don't think there is much more that could be said, right? In that sense, yeah. A couple of points for the Crown or for the respondents in this case. So yeah, for both Emily and Arjun, when you're referring, I think the appellants did a better job of guiding me to the bundle and giving me time to find the actual page. Okay, so you go seamlessly in your argument and you tell, so we have on this page, which is fine. It sort of flows, but it underestimates the time that even with the e-bundle or with the live bundle, I would need the time to go and actually find what you're telling me, right? So there is something in if I can direct you to this, give me a second or two, right? You might see me nod, or just give me a second or two, so you're sure that I'm on the page and that I found the highlighted part and that I actually started following what you're saying, right? So there is a case for giving me that extra time to go and actually make sure that because in your, so it's flowing in the argument and you tell me the page and I get the hint, okay, I should go now to this page, but by the time I get to it, you already said 3 more sentences, right, on which I haven't been completely focused on, right, because I was looking for the page. So it's a minor thing, but it helps, right? It obviously helps. In terms of presentation, again, the pace, politeness, that's all perfectly fine. Very, very professional. Now, Emalik, I had more of an impression with you that that you were not always focused on the camera, but reading from time to time. I know it's technical. There are 5 points. There's causation. There's it. I know it's hard to keep in head, but I got the impression that there was more reading than ideally you would want to have, right? Ideally, it's all the time complete focus on the judge or the camera in this case, right? So at some it goes, you're flowing. There are no gaps. There are no pauses. It's all quite well. But I had this feeling that Sunday that it was more like reading and then focusing on me and then focusing on me, which it could be done better. Arjun, on the other hand, I had the more impression of constantly being focused on the camera, right? So it's practically a matter of just how much you want to learn by heart. Ideally, everything. It's not always possible. It's better to, if you're not sure, it's better to then have a look and make sure that this is exactly correct what you want to say, right? But ideally, you look at 90% of the time you're looking at the camera. I told you already about extra time, asking for extra time. That's very good. Now, for you and Arjun, I had the feeling that in your speeches were very, very well crafted. Okay, from the legal viewpoint, rhetorical. There were the rhetorical elements, like I said, pulling on the heartstrings. That's all very good. I just had a feeling that they didn't take into account sufficiently the possibility of questions, or me asking in terms of timing, how much time will be required, if I actually ask 1 or even 2 questions, or if I ask for clarification on cases at every point that you ask me, do I need it, right? There is a risk if you're offering me the possibility to ask for you to clarify the facts of the case, right? I might say yes in every instance, okay? And that you should really take that into account when timing the speech, right? I know 7 minutes, 5 minutes, it's a very, very short amount of time anyway. But if I said yes to everything, I think there should be a wrap-up version of your speech, which is even shorter than that, right? Or you think, if I get asked, then okay, I will ask for extra time and I'll ask for 1 minute. And then I have a 1 minute wrap-up in store. And that 1 minute wrap-up needs really to be brief and short, right? So Arjun, you were over time. You asked for extra time. I gave you the extra time, which is fine. But you were going over time, and you stick to your speech, which was good. And you mentioned that pit bull terriers are outlawed, whatever, which is a nice point to add. But if you're over time, the emergency version of the speech would omit that. You would just say, no, it's a dangerous breed. Stop at this, stop that, A, B, C. Okay, I know I'm over time. I really need to wrap it up. Yeah. So there's the emergency version that needs to get activated if I ask you too many questions or if I did something like that, right? So, but it goes for all of you, of course. But I noticed with the example of the pit bull terrier, right? So there's that. So Amalik, otherwise I think that's all good. And Arjun, I told you about the wrap up needs to be the shorter version. Yeah. So when I asked you the question just came to me because a number of you were asking about, all of you were saying that, oh, it's customary for her to, smoke cannabis and whatever. It's customary. So I wanted to ask, is there any legal impact to this, right? Or something like that. Now, you might not have expected this question, which is perfectly fine, but that's the situation which you get. Now, the first thing that comes out of your mouth to me is right, and which is fine, and then you refer to cannabis as weed, right? Which is fine. I mean, I'm sure the judge will know what you're talking about, but if the case and the facts say cannabis, and if the official name is cannabis, right, and the use of slang is not required in the present circumstances, right? If you have SMS between suspects and they're saying weed, then you say, okay, well, what they're saying weed this refers to, right? But otherwise, just stick to the official, names or something. If you go into, weed or Mary Jane or God knows what, it's not what you expect in the Supreme Court, right? So there is that aspect, and I would say for all of you, when you do get to the bits which have these dramatic rhetorical impacts, take a pause, okay, and let the statement sink in. Okay, so you all had these good sentences. She came and tried to save the dog, right? Or a young life, has been lost, it has been cut off, it will never be experienced again. Those are all powerful sentences which have their purpose. But when you're uttering them, there's the theatrical moment of uttering them in a different tone, different pacing, and leaving some pauses before or after for the impact to sink in. Okay? Otherwise, it risks of getting lost. The impact is lost because you go and you say, so a young life has been lost, and if there are no further questions from your lordship, I will be ending now. That dampens the impact of such a statement. Okay, so you go, and just to remind ourselves, what are we talking about here? A young 4-year-old life will never be continued. Pause. And this is what we are dealing with today, and this is what happened. Pause. And then you proceed. Okay? There needs to be, the stronger the rhetorical value, the more you need to add the theatrical element to an extent to it, right? To get the full benefit of it. Okay? If you're there is no need to say, well, this was cited in the All England Review, right? There is no need to go all theatrical with the All England Review, but some statements require it. Yeah. Overall, I think that's it. What I had from my notes. Again, as a general point, it was a really, really wonderful session, and I really enjoyed it. And you should really all be proud of your good work.
Thank you, Velimir. Thank you guys so much for joining our demo Moot today. If you guys have any questions, you can just ask in the chat, or you can just turn on your mics. But thank you again for all our expert Mooters. You guys did a great job, and I'm so proud of you guys. Yeah, so if you guys don't have any more questions, thank you guys for coming to our demonstration Moot. But yeah, we'll just stay back a little if you guys have anything that you want to ask. But thank you guys for coming today. If you want to ask a question, you can just turn on your mic, or you could just send it into the chat. I apologize for the problem, the mooting problem previously. Hopefully you guys could see the picture. But I'm very happy with the event today. So thank you guys. Thank you, Velimir, again. I think yeah. Okay. Okay. Great. If there's no more questions, I will see you guys in our How to Moot workshop tomorrow. Yes, How to Moot workshop. Let's go. Thank you, Velimir, again. Thank you.
Thank you, guys. It was really, really excellent, and thank you for inviting me.
Thank you so much for being there.
Bye.
Thank you. Bye.
Thank you. No problem. Great job, guys.
You guys smashed it. That was actually so good. I was on the edge of my seat. I was like, damn, you guys are going in. Like, well done. Well done. Well done. Well done.
Yep. Don't forget to join our How to Moot workshop tomorrow at 12, like the same time. So, yeah. Thank you again. See you tomorrow.
Thank you.
Berlinda, one thing I did want to ask is that are current subcommittee members able to take part in the speed moot or the internals next term?
Okay, so for being in the subcommittee, you guys can join the external moots. You can join the internal, but usually if you're in the subcommittee, you would have firsthand the external moot into varsity, so you'll be representing our university. But yes, if you can make a special request to us to say like, oh, I want to join the internal moot, and the speed moot, and we'll try to accommodate that. No problem. Okay. Okay, thank you guys for coming. I'm sorry for holding you off of your lunch. It's like 1 now, so okay. You. Great job, guys. We'll see you tomorrow. Okay.
Thank you.
Bye.
Take care. Bye.
All right. Thank you, Berlinda and Dylan. So, yeah.